Welcome to Africa Express. Today we are going to be discussing a very important topic, and this topic has to do with immigration. We have with us an attorney who practices immigration. His name is Bennett Savitz of Bennett Savitz Law Offices in Boston. And he's here to actually answer some of the questions that is in a lot of people's mind regarding immigration. Attorney Savitz, you are welcome to Africa Express.
Thank you very much.
So, tell me a little bit about yourself. Your specialty is immigration law, correct?
That's right. So I've been practicing immigration law for over 20 years. That's all I do. And I've had my own office in Boston since the year 2000. I practice mainly in the area of business immigration and family immigration. So I help employers bring people into the United States to work here and get them green cards and permission to stay here. And then I work with families who are sponsoring people to come into the U.S. with green cards to live here permanently as well.
Okay, I know this sounded a little bit awkward. What is your success rate?
So generally speaking, having done this as long as I have, I can analyze a case within about a half-hour consultation. That's what I do when I first get an inquiry. And within about a half hour, I can figure out what the options are and what the chances are for success. And then we only move forward with cases that we think we have a chance to succeed on, and I let people know.
So do you take clients from just within the United States or just around the globe?
Around the globe. So, in terms of convenience, most of the clients are here, or they have a contact who's here to contact me. However, I do get inquiries from outside the U.S. for people as well, whether it's family members outside the U.S. or potential employees outside the U.S. And so I do that as well. But it tends to focus on people who are here in the U.S.
Yes, okay. But I know that probably especially with employment, people who want to migrate here with specialties, they might be interested in talking to you.
That's right, that's right.
So tell me, let's say somebody wants to sponsor a family member to U.S. How do they start?
So the first thing people need to understand is that not every family relationship is eligible for sponsorship. So you have to first check to make sure that the relationship is one that is eligible. The best relationships in terms of the ranking, and the U.S. immigration law actually ranks these relationships in terms of how many green cards are available. And so the top one, the best one, with unlimited green cards available are for what's called immediate relatives. So that's a spouse of a U.S. citizen, that's a child, a minor child of a U.S. citizen, or that's the parent of a U.S. citizen who is over 21 years old. In those three cases, that person's an immediate relative. And if that person's an immediate relative, there's no quota and no backlog. So as many of those people that are eligible can get green cards applied for them immediately. And I'll go over the process in just a moment. Because then every other relationship has a quota. So for example, there are different preference categories. The first preference category is unmarried sons and daughters of U.S. citizens. The second preference category is spouses and children of green card holders. The third preference category is married sons and daughters of U.S. citizens. And then the fourth and final preference category is siblings of U.S. citizens. So if you're not on the list I just said, then nobody else can be sponsored. So for example, married sons and daughters of green card holders are not eligible to be sponsored.
Really?
Really. So you have to be on the list. And so the list that I'm talking about is what's called the Visa Bulletin. And it's at the Department of State's website. And this is a really important document for people to look at, because not only does it give the list of which relationships, which family relationships are eligible to be sponsored, but then it also lists what the backlogs are. So for everything that's not the immediate relatives that I talked about first, all of those categories have a quota. And unfortunately, all of those quotas have more applications per year than there are green cards available per year. So therefore, there's a backlog and a waiting list of a time before somebody can get a green card to come in one of those categories.
So let's say the category 1 that you just mentioned.
Yes. So for example,
Yeah. What would we say, like timeline? Let's say, okay, I filed for my mother.
Yep.
Or father.
So if you file, again, if you're a U.S. citizen
Yes.
who's over 21 and you file for a parent, that's an immediate relative. And so you file a relative petition to the Immigration Service. Let's say it takes about 6 months to get approved. And because it's an immediate relative and there's no backlog, then that parent can immediately go through the U.S. Embassy in his or her home country and get the green card and come in to the United States with their green card. Okay.
But doesn't it depend on also the availability of visa, regardless of who?
So for the immediate relatives, it doesn't, because those are unlimited.
Okay.
For example, let's talk about two common categories that do have a backlog and do have a quota. The unmarried sons and daughters, for example, of U.S. citizens. That's what's called the first preference category, but that has a quota of about 23,000 green cards per year, and that's backlogged all the way to 2007 right now. So if you file a relative petition as a U.S. citizen parent of an unmarried son or daughter, even though that relative petition would be approved in about 6 months, it's still going to be about an 8-year wait for that son or daughter to get in line and get their green card. And that's for unmarried. So what happens if that person gets married in those 7 or 8 years, which is not uncommon?
So that changes.
That changes their category. Now they're down to the third category, and that category is backlogged to 2004. So they actually go backwards in line about 3 more years just by getting married. Another really popular category is when somebody who has a green card is sponsoring a spouse or a child, an unmarried child, again, minor, under 21. That backlog is only, fortunately, to 2013. So that person, that green card holder, would file the relative petition. They'd get it approved in about 6 months or so. And within about 2 years, then that person, that spouse or child, would be eligible to get the green card through the U.S. Embassy. That's still 2 years of having to live apart and wait.
Yes.
But it's still a lot better than some of these other longer backlogs.
Let me go back a bit.
Yeah.
A parent files. You're saying, okay, right now is backed up to 8 years. Assuming the person ends up getting married, now we are counting not even 8 years, like
It's
about
11.
10,
Yeah,
11
right.
years, even maybe longer than that.
That's right.
While this person is waiting, supposing the sponsor dies,
Yeah.
because that will happen.
That's right.
What now?
Yeah, that's a problem, because that petition becomes void, because the relative petition is only valid for that relationship, right? So there's only one exception to that for a marriage case. So for a widow or widower who where the spouse dies during this process, they can still move forward with the widow or widower petition. But for these other family categories, if a parent sponsors a child and they're in this backlog and waiting and the parent dies, then unfortunately that petition goes away. And so then that child never gets the benefit of that petition.
There's no exception to that?
No, only if they've started the green card process and have gotten far enough along and have come out of the backlog, and then they're already in the green card process, that's different. But if they're in that backlog and waiting, they unfortunately can lose all of their time that they've spent in the backlog.
So if they've already started the green card process,
Right.
And the person dies, what is that exception? What can they...
Right. So depending on where they are in the green card process at that point, if they've already initiated it, then sometimes you can work with the embassy to get the green card issued as of the date of the death, so that therefore the green card could be issued before the person was dead, and therefore the relationship still existed upon the green card issuance. If that happens, it's really important to work with an attorney to try to expedite the process in order to make sure that that gets done, because you only have one chance to get that done correctly.
So let's say for someone that is looking for work, for work in U.S.,
Sure.
How can they get sponsored? Because there's a lot of professionals outside the country.
That's right.
And they put in, especially in the medical field and science field. How do they go about it?
Yeah. So the way that our laws work for employment is that it always involves an employer sponsoring an employee. So the first thing that somebody has to do is find an employer, find a job, because they can't come to the U.S. first themselves without that job sponsorship. So once they find an employer, and they could come in, by the way, as a visitor to interview for a job, for example, and find out whether that job will work. That's okay for them to come in as a visitor to do that.
Yeah, but they come in as a visitor. Are they going to tell the embassy that they go in as a visitor to interview for a job?
Yes, and you can do that because as long as you come in for your interview and then go back, you're okay. So if you come in for your interview and then go back to your home country, you haven't violated any rules or any laws. And you'd have to be back in your home country in order for that employer to file for you to come back in and work. So let's say they've now identified the employer, they've had their interview, they get offered a job. At that point, the employer then has to file to sponsor that employee to come in and work for them. And there are several different categories that they can do that, depending on the nature of the relationship between the employer and the employee. The most common one, however, is called the H-1B. And the way that the H-1B works, it's for professional workers. And unfortunately, that's also a numerically limited category. And so there's a quota. And all of those applications, therefore, have to be filed on April 1st, because that's the deadline for filing in order to make sure you get in for that quota. So we just had that happen for this year.
So for the H-1 visa, you have to file it before April 1st.
On April 1st.
On April 1st.
Exactly on April 1st,
So
yes.
after April 1st, you can't file it.
Until
now
the next
you
year.
have to wait till the next year.
Exactly. Yes.
Wow,
That's right. So that's really tough.
Yes.
There are some other categories. If somebody has worked for an employer abroad for 1 year, then that employer can file to transfer them into the United States after they've worked abroad for 1 year. That's a really nice category because there are no quotas, and therefore you don't have to file at any specific time. So it's as soon as that individual has worked for the 1 year abroad and is eligible, then that employer can bring them into the United States.
So what type of jobs? Because I'm sure they're
Yes.
not... they're just not, United States is not letting everyone
So
any kind of work.
we're
just
usually
jump
talking
in.
about professional level jobs, meaning jobs that require a bachelor's degree level. So either a bachelor's degree or the equivalent of work and experience that is equal to a bachelor's degree. So that's the level that we're talking about. That degree can be a foreign degree, and then we get those degrees evaluated to show that they're the equivalent of a U.S. bachelor's degree. That's very common.
So there's no specific career or
Correct.
profession. It's
Correct.
just that you have a bachelor's degree.
That the position that you're being sponsored for requires a bachelor's degree in a field, specific field that you have the degree in, yes.
Oh, I see. So not a field that is scarce or anything like that. Just any field.
Any field that's a professional level position, that's right. And so, certainly there are more openings in what's called the STEM fields, science, technology, engineering, math. Those happen to have a lot more openings in the U.S. because there's a shortage of those workers. So we see a lot of applications in those fields, but it's not limited to those fields. So any field is eligible as long as it's professional level.
So let's say once somebody enters here with H-1 visa, can they change their status?
So if somebody is sponsored, for example, for an H-1B by an employer, the way that the laws work is that it's what's called employer specific. So they are authorized only to work for that employer. So if they want to switch to another employer, that new employer would have to file a new H-1B for them. So they can do that, but they would need to have that new application sponsoring them from another employer. They could change to become a student, for example, if they wanted to go back to school.
Right.
And then they would change to student status, but then they would no longer have work authorization.
So do they have to go back to their country?
No.
They can still do
Correct.
it while they're still in the country.
Yeah.
As long as the other employer can...
File a new H-1B
File a
for you.
new
That's
one.
right. So the rule is basically if you're here in one status and you're lawfully here, you can file to change to another status. The problem becomes if somebody is here and stays longer than they're supposed to and is no longer here in a lawful status, then they're no longer able to change to a different status in the U.S. And in those cases, that's when the person would have to go back to his or her home country and make the application from outside the United States.
Because they originally overstayed to start with.
Correct.
So they can't do that.
Correct.
But within that time, assuming though, let's go back a bit.
Sure.
The person came on a tourist visa. So within that, most of the time it's 6 months. So within that time, can they change their status?
So that gets a little trickier because when you come in as a tourist, you're promising the United States government that you're coming in to visit and go back to your home country. So if after you've entered as a tourist, within some short period of time, you now decide to change to something else, the U.S. government can say, well, then you lied about going back as a tourist. You didn't really intend to come in and be a tourist and go back. You intended to come in as a tourist and find a job or go to school or do something else. And now we're not going to let you change your status in the U.S. because we think you lied. So,
to start with.
Yes. So unless you can demonstrate that there was really a change that happened, something unexpected, where you really intended to come in and visit and go back, but there was some unexpected change, at that point, you'd have to prove that to the Immigration Service in order to change to a different status. Again, that's another instance where you'd really need to consult an attorney to determine whether you can make that argument that there was an actual change of circumstances that allow a change of status rather than just having to go back to your home country and apply there.
Yeah, a lot of that also happens with students. Now, someone that comes with F1 visa, going into school, and decide to change, what happens?
So again, it depends on where they are in their student status and when in the process they do this. If they're still during their student status, that's a valid status, and therefore they would be allowed to change to a different status while they're here studying. If instead they stop studying, or they violate their student status by working, doing something they're not supposed to do while they're studying, then they would no longer be eligible to change their status in the United States, and they would have to go back to their home country.
But sometimes, especially students, let's say you go into school, something happens, and you end up not being able to continue taking your classes. Can that person use that circumstance to say, look, you know, I didn't quit school, but at this point in time, this is my situation, and I intend to go back to school. Is there an exception for those type of situations?
Yeah, so the regulations do have what's called an extraordinary circumstances exception. And so, for example, you got sick, and so because of medical circumstances, you couldn't continue your studies. You can apply to change your status, even though maybe you weren't maintaining your student status at the time. But at that point, it really depends on what those extraordinary circumstances are and how long that person waited to make that application. So in other words, if you had a medical emergency and applied right away because of that medical emergency to change from student status to visitor status, the government is much more likely to approve that rather than 6 months later saying, look, I had this medical emergency and then I stopped studying and now I've been here for 6 months and now I want to change my status. The government's less likely to approve that.
Okay, let's go back a little bit. I want to...
Okay.
Let's say a student decides to work. And obviously, if they work and they're not working legally, what happens?
So here it becomes an issue of what the school knows and what the school doesn't know, because the school is obligated to report any unauthorized employment by a student. So if the school finds out that a student has been working without authorization, they have to let the government know, and they wind up terminating that person's student status because that's a violation of student status. If the school doesn't know, then unless somebody finds out, that student wouldn't be known to be violating his or her status, and it might not come up. But then it's a question of course, it's not allowed to do it, but who finds out and who knows about it?
How did they get to know about
Exactly.
it? Let's go back a little bit again to tourist visa.
Sure.
A lot of people, yes, they come. and they overstay. Once that happens, what can that person do?
Okay. So yeah, this is a really important issue and a problem that people don't, I think, understand how serious it is. Because two things that people need to know about overstaying a tourist visa. Number one, the first day you stay longer than you're allowed to be here as a tourist, the visa in your passport is automatically canceled. So that visa in your passport is no longer valid for future travel. So you lose the right to travel back and forth ever again on that visa. So that happens with just 1 day of overstaying a tourist visa. The second thing that a lot of people don't understand is that once somebody comes in as a tourist and stays beyond the date they're supposed to, the clock starts counting for the days that they've stayed. And if they get to 180 days of staying beyond the time they're supposed to, and then they leave the US, they are barred for 3 years before they can come back. If they stay for 1 year beyond the date they're supposed to stay and then leave the US, they're barred for 10 years before they can come back. And a lot of people don't understand that those bars are automatic based on overstaying and leaving in that period of time. And once you overstay, of course, as I talked about before, once you overstay a tourist visa, unless there's extraordinary circumstances, you're no longer eligible to change to another status because you're no longer in a valid status. So the only way to get a new status is to leave. And if you've overstayed for that amount of time and you leave, you have that bar before you can come back in. So it's a real catch-22 situation for people who've overstayed tourist visas.
But if someone overstays and immediately files for adjustment, what?
Okay, so then we talk about the one exception to the rule that I just mentioned, and that when you talk about adjustment, what you're really talking about is getting a green card based on a marriage to a U.S. citizen. Because that's the one thing that kind of trumps all these other rules. And that is, even though you cannot change from one temporary status like a visitor to another temporary status if you've overstayed, if you get married to a U.S. citizen, and again, you're now an immediate relative, as we talked about before, which is the highest category for family cases, the government excuses that overstay and allows you to file to get your green card in the United States so you don't trigger that bar by leaving the United States.
Regardless of how long you overstayed.
Correct.
Once you are married to a U.S. citizen,
right.
That kind of overrides it.
That's the trump. That's right. That's the most important thing. So I've had cases where somebody came in as a visitor 15 years ago and was only allowed to stay for 6 months. And they stayed more than that, and now it's almost 15 years later, but they're married to a U.S. citizen, so they're still allowed to get their green card in the United States because that immediate relative trumps the fact that they overstayed their visitor status.
So they don't have to go back to their home country to
get the green card.
Get the green card.
Right.
They can get it here.
Just in that one case, the marriage to a U.S. citizen. Any other case, they can't. So in all other cases, they're stuck because they cannot get the green card in the U.S. They would have to leave, and then they would be subject to that 10-year bar at that point.
Are there penalty to stay, like when you change your status under those circumstances, and now you're married? Is there any penalty they have to pay?
Nope. That immediate relative petition, like I said, kind of makes everything else go away, and it fixes everything. That's the one exception.
Let's talk about what is on everybody's mind in America.
Okay.
The president not long ago made an announcement regarding immigration, and I'm sitting here, I'm confused about where, what, how, and I'm sure a lot of viewers out there, they want to know, really, get some kind of clearance in terms of what they're supposed to do, who does it apply to, and when and where. So tell me a little bit about the president's announcement.
So the president's announcement at the time last year was very exciting, and a lot of people were very much looking forward to a category of about 5 million people or so that would wind up being protected by these announcements. And these are generally people who are either parents or children who were here for a very long time in the U.S. unlawfully. In the case of children, maybe brought here illegally, when they were kids and then are still here, and for parents who had come here illegally and are here illegally but had U.S. citizen children. So a lot of people who are here unlawfully now would have been protected by this. And so we were all very excited. And as soon as this was about to take effect earlier this year, there were lawsuits blocking these things from going into effect. And so that's where all this confusion comes from. Because right now, all of the things that the president announced, none of those have been taken effect yet. And none of those can take effect until they go through this lawsuit where the president is basically being sued, saying that he can't do these things, and he's arguing that he can do these things. Mm-hmm. And so now it's in a court, and it's up to judges to decide whether the president can or can't do these things. So the two most important things to know right now is that there are no new laws in effect. Nothing is changed because everything the president announced is on hold until the judges make that decision. Okay. And therefore, the second thing is, do not pay anybody anything who says to you, oh, there's a new law, I can help you, there's a new program, because none of that is true. Because until these lawsuits are done and have figured out what can be done and what can't be done, all you're doing is paying money that is going to go to somebody who's not going to be able to help you.
Yeah, because of the lawsuit.
Because of the lawsuits.
Now, when you were talking earlier, let's say a parent legally brought a child. The parent came in, it's illegal, is legally here, and also the child entered legally, but never at any point filed for the child. And now the child is an adult. Would they fit under this president?
Under the president's new announcement last year that is not in effect, they potentially could be helped if it's allowed to go through by the court. But until that is decided, again, none of that can take effect.
I see. Okay. One last thought. What is your advice for someone who probably staying here illegally? And on deportation, although we are going to get into that subject,
sure,
but the government already know that they put them on deportation. What would you advise that person to do?
So two things, I think, if you're in that situation. First of all, at that point, you have to talk to an attorney, because if you're already in the immigration court system in deportation proceedings, there's now going to be a limited number of things that you can do to try to defend yourself against deportation. And if you're not eligible for one of those limited things, the best thing you might be able to do is ask for the government to let you leave the United States voluntarily. It's called voluntary departure. And if you can do that, you can leave without having been considered to have been deported. And if you've been deported, there are lots of penalties that won't let you come back to the United States for many, many years. But if you leave voluntarily, then you're not subject to any of those penalties. So it's really important at that point to talk to an attorney and find out, do I have any options to defend myself from being deported? And if I don't, maybe I'm better off doing this voluntary departure.
Okay, I want you to hold that thought. We are going to take a break, and we'll come back and we'll talk a little bit more in depth on this subject.